Our next speaker will be Ewan McKendrick, professor at the University of Oxford. Ewan, I should add that Ewan was my supervisor during my time at Oxford as a DPhil student, and we have a long relationship. But we haven't seen each other in person for a long time due to the pandemic. So this is the first time, despite many email communications, this is the first time we have seen face to face. So it's a very pleasure to have you here. Ewan is a leading lawyer on English contract law and international commercial law, so which does not require much introduction from me. His topic today will be focused on Article 79 of the CISG. So, Ewan, if
can you hear me? Yeah.
Yes.
Yeah. Sorry, I just realised I forgot to unmute myself. Chow, it's great to see you again. It'll be nice when the point in time comes when we can meet again in person. But one of the things I really want to talk about in some ways is the current pandemic, and look at Article 79 of the CISG. So I'm taking a much narrower approach than in the previous papers. And I think sometimes there is a value in looking at a single article. I'm not going to suggest that the decision to adopt or ratify or not will turn on Article 79, but I think it's a useful case study nonetheless. It gets relatively limited treatment in the consultation paper, I think for entirely understandable reasons. And the focus, particularly in Annex 2.2, is really on comparing and contrasting the Article 79 with the doctrine of frustration as it currently operates. And as Alex Loke points out, that the real difference would appear to be much more in the remedial sense rather than in the sphere of application. There is a suggestion, which I think is broadly right, that Article 79 is broader than the doctrine of frustration, but it's really the remedial consequences that differ. And what I want to do in the presentation, I apologize for the fact I don't have a PowerPoint presentation, but I got back from holiday yesterday evening, and so I'm just working my way back into the world of work again. But you know, when we think of when my scientist colleagues here in Oxford are working on the vaccine, COVID does not respect jurisdictional barriers. It's a global pandemic. But when we as lawyers think about the pandemic, we tend to look at it very much through the lens of national law. And the question here is, what contribution might Article 79 have? Is it possible to have a broader international resolution of these issues? And I think what we'll see when we look at Article 79 is that it's not an entirely satisfactory provision. Professor Barry Nicholas said of Article 79, it's one of the longest in the convention, and its drafting took up a great deal of time, but the outcome is in several ways unsatisfactory. So it was always, I think, a difficult provision. There's been a lot of academic discussion of Article 79, but relatively little case law. And what I want to do is just to look very briefly at the structure of Article 79 and then make a couple of points by way of conclusion. First, if we look at Article 79, it's headed exemption. So the question is, exemption from what? And when you look at Article 79.5, you see that what it is essentially doing is providing an exemption from liability in damages. And as is pointed out in the consultation paper, in this respect, Article 79 is very different from the doctrine of frustration, as common lawyers understand it, which leads to the automatic termination of the contract. As the consultation paper points out, Article 79 is suspensory rather than extinctive, And citing Michael Bridge, it says it's more flexible to cope with both partial and temporary frustrating events. So it's essentially providing a shield from liability and damages. But when we break it down further, if we take Article 79(1), what it says is the party is not liable for a failure to perform any of his obligations if he proves that the failure was due to an impediment beyond his control and that he could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract or to have avoided or overcome it or its consequences. There's three elements there. One, it's beyond his control. The pandemic will generally be beyond the commercial party's control. It's also an event they couldn't reasonably be expected to have taken into account. I mean, I'm discovering with some cases on COVID that is proving to be an issue of contention, but I think it's largely an evidential point. At what point in time was the awareness of the pandemic such that the parties could reasonably be expected to take it into account? But the third issue is the point I wish to focus on in this context, and that's the meaning of the word impediment. So when we think about impediment, how do we approach it? And the instinctive common lawyer's approach, and it may well be civilian lawyers have a similar approach, is to go back to your own legal system and to compare it with your existing legal doctrines. But of course, what we should be doing is looking at the word impediment as it appears in the text and giving it its autonomous interpretation and not simply seeing in it a reflection of national law. And of course, that raises one of the points that has already surfaced in the papers that preceded this, where you're talking about how to train both students, barristers, and judges in how they go about interpreting this provision. Because if you look at the predecessor, Article 74 of ULIS, the term used there was circumstance, and that was thought to be rather too flexible, too liberal. So the choice of impediment was one taken with the view to try to narrow the sphere of application. And what it does is it applies most obviously to, I would submit, a physical impediment, something that actually prevents performance from taking place. So that if what you have is a case where COVID-19 actually results in it is no longer possible within the time frame to perform the contract, then you do have an impediment in principle. Much more difficult, and a point I'll come back to towards the end, is what do you do in the circumstance where it is perfectly possible to perform the contract, but it has simply become much more expensive to do so? Can that economic impairment fall within the definition of impediment, and how do we work out whether or not it can fall within that definition? So you can see 79(1). I think it's ideas that people can readily understand from their own national law. But a couple of other points I wanted to pick up on was firstly in Article 79(4), which deals with notice provisions. And it says the party who fails to perform must give notice to the other party of the impediment and its effect on his ability to perform. And this to me raises a more general point about the CISG when I look at it from a common lawyer's perspective, that it relies much more than the common law does, as it seems to me at least, on notification obligations. And here, what you have is a mandatory requirement that notice be given. Now, you can sometimes find the same in standard force majeure clauses in contracts, but these contracts come in different shapes and sizes. In some, notification is a condition precedent. Other cases, it's not. But sometimes where the condition precedent language is used, what it means is that you can't call force majeure unless you go through the notice provision. That is not what Article 79(4) is saying. What it's saying is that if you don't give notification, then your liability is one in damages resulting from the non-receipt. Now, it doesn't seem to me to be immediately obvious that there will be a substantial claim for damages in the case of the non-notification. But I think it's interesting to see that Article 79.4 imposes this notice requirement, but then it simply provides that the remedy for non-compliance is one in damages. And then lastly, 79.5 is a provision that reads very oddly from a common lawyer's point of view, because what it's doing is it's simply shielding the liability in damages, shielding a party from a claim for damages. Now, there is a sense in which force majeure clauses, as appear in commercial contracts governed by English law, very often perform this type of function. But what it means is there's no automatic termination of the contract. On the contrary, specific performance might, in an exceptional circumstance, be available. I tend to think that's a relatively remote possibility, but trickier, and it's a point I don't have time to deal with, is how it relates to termination, because I think it was Alex Loke was pointing out that what you then have to do is, if you wish to terminate the contract, then refer back to the provisions in the CISG dealing with rights of termination. So that then is the broad structure of Article 79. But the point I want to conclude with, and then pick out a couple of general points from it, is what do you do about the case where there's a change in economic circumstances so that it is physically possible to perform? It's simply become much more expensive to do so. That's clearly not a physical impediment, but can it nevertheless fall within the definition of impediment in the CISG? Now, here I just want to use this point to make some more general points. One is, I think, that there is this difficulty with the CISG that it is locked in time. It was agreed in the late 70s, and it very much reflects the thinking of that time. One of the interesting things for me about the COVID pandemic is the explosion of academic literature on force majeure and related doctrines. And what is clearly becoming apparent is the ideas of change of circumstances, of hardship, or adaptation of the contract are becoming much more important. But yet, they find no obvious place within Article 79. So you have this problem then that you're signing up to a document that is locked in time. Secondly, you then look to the point, what do the cases tell us? What do the academic commentaries tell us? And what they seem to me to do is to paint a very mixed picture. You can find some cases where a change in economic circumstances is held not to amount to an impediment, some cases where it is held to be sufficient to constitute an impediment. And one of the important features, I think, of the CISG, which hasn't really featured in our discussions so far, is the role of the advisory committee that Michael Bridge chairs, where what it has done is valuably produced opinions which don't have legal effect, which can both clarify points of ambiguity, deal with conflicts in authorities and suggest which might be the preferable one, and also, I think, deal with some situations which probably were not adequately covered in the CISG itself. And this seems to me to be a valuable way of breathing life or new life into the CISG. Of course, it doesn't have the authoritative stance of the CISG text itself. It doesn't purport to have that, but it can have some guidance. And opinion number 7 is actually dealing with Article 79. And when I was preparing for today, I actually looked at it again, and I looked to see who had written it or who the principal author was. But the point that struck me was not the author, but the venue where it was adopted, because rather extraordinarily, it was adopted in Wuhan in China. And there are lots of academic conspiracy theories around the pandemic, but I've never seen the CISG advisory committee in any way linked to it. But if you look at that document, I think with all respect, it's not the clearest of opinions, but what it does seem to me to be pointing to is that in truly exceptional cases, it might, a change in economic circumstances might amount to an impediment. And the concern here is once you begin to go down that route, it then gets a much more liberal interpretation than people perhaps intended. It seems clear to me from the advisory committee opinion that they intended this to be construed narrowly, but there is a decision of the Belgian Supreme Court in a case called Scafom and Lorraine Tubes, in which a 70% increase in price was held to be an impediment. And that seems to me to be a much lower threshold than other people have suggested, where it's been suggested somewhere between 100 and 200% may be more likely to be an impediment. But the point here is that you're looking at the text for impediment, and then you're looking at the range of materials on which you can draw, which are rather different from those which you would address certainly in the High Court. But the next point, and this is, I'm getting towards the end now, is that once you go down the change of circumstances route, what's the remedy that the parties may wish to have? Because what you may want from the court is not shielding from liability and damages, nor the termination of the contract, but the adaptation of the contract to reflect the changed circumstances. And one of the interesting features of the Scafom case is that what the Belgian Supreme Court does is, having held that the contract was governed by the CISG, then jumped to the UNIDROIT principles of international commercial contracts to fashion the remedy. And so here you've got this much broader question, which again, I don't have time to touch on, but I think is an interesting one to think about, is locating the CISG in the much broader range of international materials that are now available. Because in short, the point is this: what do you do in the circumstance where the CISG appears not to provide an answer to the particular problem? And the instinctive common law reasoning is that if a statute doesn't provide the answer, you go back to the underlying common law. But there's clearly a reluctance in some quarters to conclude that where the CISG runs out, you then drop back down to national law, because the whole aim here is to try to find uniform solutions to these problems. And you can see that there is a temptation to jump from the CISG to the UNIDROIT principles. But the question is, what's the legal analysis that enables you to do that? I've seen some people say, well, you start with the UNIDROIT principles, which state that they perform that function. That seems to me the wrong way around. I don't think that this UNIDROIT principles can give themselves a jurisdiction they would not otherwise have. And it seems to me the answer must lie in the CISG itself, probably in Article 7.2. And the question then is whether that article can provide a framework on the basis of which you can, in an appropriate case, conclude that the UNIDROIT principles can gap fill or provide answers to problems that fall within the scope of the convention but are not answered within it. Now, this question about whether or not you can adapt a contract is, I think, an extremely complex one, and my time is more or less gone, so I'm not going to go into it anymore. But the kind of 2 points that I wanted to pull out of here is, I think, the important role that the advisory council plays in terms of providing opinions, which can help facilitate the use of the CISG. And the second is, to what extent can the UNIDROIT principles play a role in supplementing the CISG? And just by way of conclusion, that brings us back to, I think, the point about the importance of training both students, lawyers, and judges in terms of the way in which they approach the CISG in a case where it's found to be applicable. Because it seems to me that in the COVID situation, Article 79 probably works well enough in the case where performance is physically prevented and you simply want to be shielded against a liability and damages. Where it doesn't work so well is in the case where it's become more expensive to perform and you wish to adapt the contract. And here the question is whether or not the CISG can provide an answer via the UNIDROIT principles or whether you go down to national law. But at the end of the day, it may be that this is not a fundamental issue for the CISG because in many cases, the issue might be resolved by the parties in the form of the terms of their contract. And as previous speakers have pointed out, the CISG does enable party autonomy so that if you make your own provision for it, and many contracts governed by English law at present will attempt to make provision through force majeure and hardship. And on that basis, then Article 79 performs a function as a default rule, which may be of relatively limited practical significance. But nevertheless, it seems to me that Article 79 is not the best example of a well-functioning article in the CISG. It is a child of its time, and there is a question as to whether or not the UNIDROIT principles can perform a function of enabling adaptation to take place in a circumstance where that appears to the court to be the most appropriate remedy. Thank you very much.